The Illinois Supreme Court is now deciding whether the state's recently enacted assault weapons ban.
Lawmakers officially gave the green light to an historic statewide assault weapons ban in Illinois.
Governor Pritzker signed the bill into law back in January. The Supreme Court is considering putting a temporary hold on the legislation.
Of domestic abuse, you shouldn't have a gun. If you're on social media threatening the lives of people, you shouldn't have a gun.
A U.S. district judge temporarily blocked the enforcement of the ban, later overturned by the state circuit court.
Their legal analysis is poor, their conclusions are misguided, their outcomes are dangerous.
Supreme Court decision. Arms rights advocates have recently escalated their legal battle against Maryland's ban on attack arms, such as the AR-15 semi-auto rifle, by petitioning the U.S. Supreme Court to take up their challenge. This move comes in response to the Fourth U.S. Circuit Court of Appeals' unusual decision to allow all 14 of its active judges to hear the case, instead of a 3-judge panel that had previously heard arguments. The petition, filed by 3 prominent arm rights groups, the Second Amendment Foundation, Firearms Policy Coalition, and Citizens Committee for the Right to Keep and Bear Arms, characterizes the Fourth Circuit's actions as the most brazen example of appeals courts disregarding the Supreme Court's precedents on the Second Amendment.
The Illinois Supreme Court is now deciding whether the state's recently enacted assault weapons ban
Is it the most robust, far-reaching gun law in the history of the world? It is not.
Members of Congress are also trying to answer what the Attorney General just called the most difficult question in a democracy.
This is a violation of that federal law. The federal judge that initially ruled in this agreed, saying it's up to Congress.
Their legal analysis is poor, their conclusions are misguided, their outcomes are dangerous.
They argue that the decision to hear the case en banc, or before all judges, suggests a desire to overrule the initial panel's decision, which may have been more favorable to the arm rights advocates. Adam Kraut, executive director of the Second Amendment Foundation, expressed concern over the Fourth Circuit's move, suggesting that it indicates a disagreement with the panel's stance on the case. He highlighted the significance of the issue, emphasizing that the constitutionality of bans on semi-auto rifles, like Maryland's, should be clear in light of a landmark Supreme Court ruling on arm rights in 2022. The crux of the legal argument revolves around the interpretation of the Second Amendment, which guarantees the right to keep and bear arms. Arm rights advocates contend that Maryland's ban on attack arms infringes upon this constitutional right, particularly in light of recent Supreme Court jurisprudence. They assert that the precedent set by the Supreme Court's 2022 ruling supports their position and renders such bans unconstitutional. Opponents of attack arm bans argue that these arms are commonly used for self-defense, sporting purposes, and other lawful activities, and therefore should not be subject to blank prohibitions. They contend that restricting access to these arms unfairly burdens law-abiding citizens and undermines their ability to exercise their Second Amendment rights. On the other hand, proponents of attack arm bans argue that these arms pose a significant public safety risk due to their high lethality and capacity for rapid fire.
Lawmakers officially gave the green light to an historic statewide assault weapons ban in Illinois.
The appeals court that was asked to step in and allow the regulations to continue agreed with the district court judge.
Maybe now they've just priced you out of the market because you can't afford to pay those fees to get a permit.
And they're saying, they have the authority to do that. The gun rights groups that are suing.
People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year.
They point to numerous instances of mass slayings involving attack arms and argue that restricting access to these arms is necessary to prevent further loss of life and enhance public safety. The legal battle over attack arm bans is not limited to Maryland, as similar laws have been challenged in other states and jurisdictions across the country. These cases often raise complex questions about the balance between individual rights and public safety, as well as the proper scope of government regulation of arms. At the heart of the matter is the interpretation of the Second Amendment in the modern context. The Supreme Court's landmark rulings on arm rights have provided some guidance, but many legal questions remain unresolved. The court's decision to hear or decline to hear the challenge to Maryland's attack arm ban could have significant implications for arm laws nationwide. Regardless of the outcome, the case highlights the ongoing debate over arm rights and regulations in the United States. As the legal battle continues to unfold, stakeholders on all sides of the issue will closely monitor developments and seek to advance their respective positions through litigation, advocacy, and public discourse. Attack arm ban. The legal battle over Maryland's ban on attack arms, particularly semi-auto rifles, has escalated following a significant ruling in New York State Rifle and Pistol Association versus Bruin. In this case, the Supreme Court's conservative majority, in a 6-3 decision, affirmed an individual's right to carry a handarm in public for self-defense under the Second Amendment. Additionally, the court established a new test for assessing arms laws, emphasizing that restrictions must align with the nation's historical tradition of arm regulation. In response to this landmark ruling, arm rights groups, including the Second Amendment Foundation and Firearms Policy Coalition, along with several individuals and an arms retailer, have petitioned the Supreme Court to decide whether law-abiding citizens are permitted to possess semi-auto rifles, such as those covered by Maryland's ban, for self-defense purposes. They argue that the court's recognition of the right to carry handarms in public underscores the broader protection afforded by the Second Amendment, including the right to possess commonly used arms for self-defense.
A U.S. district judge temporarily blocked the enforcement of the ban, later overturned by the state circuit court.
That they have taken away our right to have reasonable restrictions. We can have restrictions on speech.
They are coming for your guns. They're listing them out in this extensive legislation.
Governor Pritzker signed the bill into law back in January. The Supreme Court is considering putting a temporary hold on the legislation.
For a case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past.
The petitioners contend that the Supreme Court's intervention is necessary to clarify the constitutional status of semi-auto rifles and ensure that law-abiding citizens are not unjustly deprived of their Second Amendment rights. The legal strategy employed by the arm rights groups includes a request for the Supreme Court to review the Maryland attack arms ban case through a mechanism known as a certiorari before judgment. This approach seeks to expedite the review process by bypassing the intermediate appellate court and bringing the case directly to the Supreme Court. By doing so, the petitioners aim to expedite a definitive ruling on the constitutionality of attack arm bans, which could have far-reaching implications for arm laws nationwide. The significance of the Maryland attack arms ban case extends beyond the state itself, as its outcome could set a precedent for similar laws in other states, including California, which also imposes restrictions on rifle ownership. The petitioners argue that striking down these bans is essential to prevent future infringements on Second Amendment rights and ensure that individuals can lawfully possess arms for self-defense and other lawful purposes. The legal background of the case involves prior challenges to Maryland's attack arms ban, notably the Colby case, which upheld the ban using intermediate scrutiny. Despite initial success in challenging the ban before a 3-judge panel in the Fourth Circuit Court of Appeals, the ban was ultimately upheld by an en banc panel of the court. The petitioners in the current case seek to overturn this precedent and establish a clearer standard for evaluating the constitutionality of attack arm bans. Arm rights petition to Supreme Court. At the heart of this legal battle is the interpretation of the Second Amendment to the U.S. Constitution, which protects the right of individuals to keep and bear arms. The landmark case of New York State Rifle and Pistol Association versus Bruin, decided by the Supreme Court's conservative majority in a 6-3 decision, established that the Second Amendment encompasses an individual's right to carry a handarm in public for self-defense. The ruling introduced a new standard for assessing arms laws, emphasizing that restrictions must align with the nation's historical tradition of arm regulation. Building upon the precedent set by the Bruin case, arm rights groups argue that it is time for the Supreme Court to clarify whether law-abiding citizens have the right to possess semi-auto rifles like the AR-15 for self-defense. They contend that Maryland's ban on such arms infringes upon this constitutional right. This argument gains further weight considering that 9 other states also impose similar restrictions on attack arms. Arm rights advocates assert that the Supreme Court's intervention is necessary to affirm the protection of semi-auto rifles under the Second Amendment. They emphasize that these rifles, including an AR-15, are widely used by responsible arm owners for lawful purposes such as self-defense and recreational shooting. The ban on these arms, they argue, unjustly limits citizens' ability to protect themselves, their families, and their homes. In response to the arm rights group's petition, Maryland Attorney General Anthony Brown, a Democrat, has defended the state's attack arms ban as necessary for public safety. However, proponents of the Second Amendment challenge the effectiveness of such bans in reducing armed violence, pointing out that criminal elements often obtain arms through illegal means, regardless of legal restrictions.
A legal challenge to the Illinois assault weapons ban is being heard in federal court in Chicago.
For removing weapons of war from the streets of America, we're actually telling them to repeal the Second Amendment.
Governor Pritzker will sign Protect Illinois Communities Act in the next hour.
That's not a right of government. That's a right that each of us has as Americans.
Of domestic abuse, you shouldn't have a gun. If you're on social media threatening the lives of people, you shouldn't have a gun.
Amidst these developments, arm rights groups have taken proactive steps to expedite the legal process and bring the case before the U.S. Supreme Court. By filing a certiorari before judgment, they seek to bypass further delays in the appeals court and secure a definitive ruling from the nation's highest court. This strategy underscores the urgency and significance of the Second Amendment challenge to Maryland's rifle ban. Ultimately, the outcome of this legal battle could have far-reaching implications for arm rights and arm regulations across the U.S. A favorable decision from the Supreme Court could reinforce the constitutional protection of semi-auto rifles and establish clear guidelines for evaluating arms laws. Conversely, upholding Maryland's ban could embolden other states to enact similar restrictions, further intensifying the debate over arm control and individual liberties. That's all for this video, folks. See you next time.